what does it mean? Strike that. I'm his mother.
Okay, it just means that that because no one is appearing that noted up the actual motion, he'll just need to reserve a docket notice to get it back before the court.
Well, Kurt Agnostius is supposed to be his attorney, and I thought he was supposed to be there.
Has he entered a notice of appearance in this matter?
I got an email with him doing that. And my son's right there, so
Okay.
Miles, you can say something. He's in treat currently, but I don't think that that's what he wants.
Okay, hold on. So, sir, are you one of the parties of this action?
Yeah.
Okay.
Miles?
All right. So you're Mr. Radcliffe. All right.
Yeah.
So the request is to continue this matter for 3 weeks. Looks like there was, I do have some notes of returns of service, but they look like they've just occurred within the last few days. In Cowlitz County, you generally need 3 weeks of notice prior to the case being heard. So the request is to set over for 3 weeks, just so that your action is timely, and then it can be heard in 3 weeks' time.
So
Are you okay with that, son?
what?
So hold
Are
on.
you okay with that?
So, ma'am, if you're not an attorney, you can't be speaking on this docket. If you're not an attorney or one of the parties, then
I'm his mother.
I understand that doesn't make you an attorney or the party. So, sir, the request is to set over, meaning I can't hear your matter today because it's not timely served. That just means you didn't serve it early enough to have it heard today. The rules say from the day you serve, meaning the day that they receive the paperwork, there has to be 3 weeks between that day and the day of the hearing, and there wasn't in this case. That happens. That's not a negative statement on your part. It's just that we need to have, the other side needs to have the right amount of time to respond. So the request is a set over, meaning just move the hearing date from today until 3 weeks from today. Do you understand?
Yeah, so I don't have anything. So that means they could have my kid for another 3 weeks?
It would be 3 weeks. So the court will hear the matter in 3 weeks. So that's going to be my order. Instead of just striking it because the service wasn't timely, meaning you'd have to redo some of it. I'm just going to set it over to that new date. Mr. Agnostu, are you involved in the Radcliffe and Aldridge matter?
Only peripherally on behalf of the Fletchers.
Okay. There's a motion before the court today. It wasn't timely served. I'm going to move that to August 17th.
Okay. Correct. I was trying to help the petitioner, the father, getting that served. It's been difficult. So August 17th.
Yep. And I'd encourage you to check the court record. It looks like there are some returns of service. They just had happened very recently. Yes.
Right.
And so that's why we're looking to set over. So, okay.
Right.
So with that, over to
Romeo
Allen or
Thank you.
Edlina Allen. Have anyone for that cause number? Again, this is Allen and Allen, Romeo Allen and Evelina Allen. Oh, ma'am, is that you in the booth? So if you tap the screen down at the bottom, you'll see a little old-fashioned microphone appear. There you
okay. You're welcome. Thank you.
All right. So this is on today for finalization. For a finalization to occur, you have to provide the court with paperwork that allows me to enter final orders. Did you do that in this case?
I took the papers to the police department and they went to his house and they say that the person that was there say that he's out of state. And the next day, another policeman went and he said nobody was home.
Okay. So what you're looking, so you don't have to, so it looks like you haven't been able to get him served. Is that right?
Not this time, just the first time, but not.
Okay. So you don't have to come before the court for service issues unless you're asking for specific relief. I'd encourage you to reach out to legal aid. They may be able to help you with understanding some of the rules regarding service and some alternatives for service. And then once he's been served, there's a minimum of 90 days between the day of service and when you can finalize. Does that make sense?
Yes, but if I don't know where he lives anymore.
And then that's where I'm going to encourage you to talk to legal aid. They may be able to give you some direction on what to do when you don't know where someone lives anymore.
Okay.
Okay. So what I'm going to do is I'm not going to take any action on your case today because he hasn't been served. I'm not going to schedule any future court hearings. When your case is ready, you can schedule another court hearing to have your matter heard. Ms. Powers.
Okay, sounds
Do
good.
I have
That's it for
Leslie
today.
Lytle
Okay, thank you.
or Thomas York? All right, they do not appear to be present. I did see that the state sent proposed orders.
Yeah, we did mail those out to the parties on June 23rd. Neither party has responded to our office or in the court file. And we'd ask the court to go ahead and enter our order as proposed.
Very good. I did see that in the court file as well. Appreciate that. And the court is signing those orders. 690.
Thank you.
Thank you. I have Ms. Corey. Do I have Cameron Miller or Taylor Young? All right. So Ms. Corey, this matter had come before the court on an issue of fees and review. Why don't you give me an update on what's happening?
Well, I'm about 10 hours in and have not yet received payment from Mr. Miller. I have received payment from Ms. Young. They indicated to me recently that they have come to an agreement on the parenting plan. And I'm just wondering what to do now. I have one small issue with their parenting plan that hopefully can be worked out between them. But I don't know what to do. I need the court's input here.
Fair enough. So let's do this because it sounds like there's a potential agreement. Why don't we put the matter over because it's already set for review? Why don't we put it out 3 more weeks to August 17th? That gives you an opportunity to see if they can resolve that issue, have a proposed order, and ideally appear on the docket. We can address the order if there's an agreement, and we can also address payment. And I would be clear to Mr. Miller that he is obligated to pay your fee, and the court can consider a judgment or other relief potentially if he fails to pay that.
Okay.
All right. So over to the 17th, and hopefully fees are paid and we have an agreed order by that time. Welcome, sir. I see you both there.
Thank you.
Hi. So what I see, and I do see that you submitted a proposed order. Let me get your case up here real quick. So when I look at your file, there was a petition for adequate cause, or a petition to modify, and a request for adequate cause. But then I see a prior motion for adequate cause. And then I see that the court previously this month denied adequate cause. So there's an order where adequate cause was denied. And so that's sort of usually the end of a petition to modify is when someone has made a petition to modify and the court has made a ruling on that, then that petition is kind of dead. It's done. It's completed. So, and before the court could make another decision on a modification, there would have to be a new request for a modification that's filed that's based on different facts than what were alleged in the last petition to modify. Because the court considered the last petition, said, no, that doesn't get us to that threshold. And that doesn't preclude people from filing another petition, but it would need to be on facts that are different than the facts that the court's already considered.
Okay, so I was the one that made the first adequate cause, and I did not realize that the dates were changed. And so I thought court was on Friday and it was originally on Thursday. And so that's why I was not present for that court date. So then when I went into the courthouse, they told me that I needed to file a new adequate cause and gave me highlighted whatever paperwork I needed to go to grab. And I filed them. I had someone serve him, but I don't know.
Okay. I appreciate that. The court system is very challenging and confusing if it's not sort of your primary job. So I appreciate that. That doesn't change my position today. If you want to potentially, there are things that you can file that potentially you could ask the court to address that issue. That's not before me today, though. And because I'm sitting in this role, I can't advise you, meaning I can't give either of you advice on sort of what to do or how to do it. I can explain sort of why the court did what it did, but not direct anybody on what to do or how to do it. So for today's purposes, I'm not going to take any action today because the court's already made a ruling. And you can talk to an attorney or legal aid about sort of what to do next.
Okay, perfect. I appreciate it.
All right. That's it for today on this matter. I appreciate you both being here.
I have a question.
Sure.
So we're just supposed to keep doing the video calls then? I can't. In my declaration, I requested
Hold on.
change.
Do one thing for me first. Your video and your audio are really choppy. Usually the video portion of our feed takes up a lot of our bandwidth. So could you turn your video off for me and then ask that question again? All right, go ahead and ask your question.
So would you like us to continue doing the video chats, or I requested in my declaration something else we could do? Is that not in consideration? We're just supposed to just scrap everything then today, Your Honor?
So what you have is you should have an underlying parenting plan. So you have a parenting plan that was entered in April of this year. That is what you should be following.
Okay, perfect.
Okay, that's it for today. Thank you both.
I am here.
Thank you.
Good, I see you. Thank you, Molly Watson. And there had been a request to send this to mediation.
Yes.
Okay, and I do have an order transferring your case to mandatory mediation.
The gal just got a hold of me. We just got in contact because they do everything via email for privacy. So she was able to confirm my email. I gave her Joshua's information. So I'm hoping she was able to get a hold of him because obviously he has to agree to do this so we can continue. So that's all we're waiting on. And I guess that's it. I'm just, we're waiting, I guess, to start the process.
So I appreciate that. It looks like you potentially have a hearing next week. Is that correct?
Yeah. So the other judge set it over to touch base again.
Okay.
So hopefully, I'm not sure if it'd be completed by then, but we'll touch base if we've finally had communication.
With the GAL or with mediation?
With me, Josh, and the mediation, hopefully finally starting this.
Okay. What I need to do, go ahead.
Sorry. The gal, the mediation gal did send me a paper to print for like starting the process for me to fill out if I need like financial relief, stuff like that. So.
Okay. Got it. So here's, I'd prefer everyone to be present, if at all possible, for this hearing where we're going to transfer, just so everybody understands that that's happening. And I know that we have a hearing set for next week. Okay, so it's actually set for the second. Okay, at 9 a.m. So here's what I'm going to do. So I'm just going to put this issue over on the mediation over to that hearing, that same hearing on the 2nd. The idea being that my preference would be that if I have you and Joshua Watson both present, it's more likely we'll have a smoother process when everybody sort of understands what's happening next.
I think maybe he thought like this one was canceled and he's supposed to come at the next one. When I called the mediation, they Cowlitz County Courthouse, they were like, just attend in case. So that's why I'm here, just in case. So he probably thought it's the next time.
That's very well, when you have several court dates, that can happen.
Yeah.
My kind of note was it looked like this was also on for the 2nd for entry of that order. So
Yeah.
it's better to have everybody present at the same time.
Yes.
More likely we'll have success in kind of getting everybody to move forward in your case.
Okay.
Just appear on the 2nd at that next hearing date. And if you have any way, let the GAL know as a reminder. If you have communication with Joshua, let him know.
Okay.
We'll go from there.
Okay, great. I did have a question. I'm not sure if you can answer. It had to do with DCS, the prosecutor handling the case as well because of our divorce. I'm kind of confused because they're handling it, but then I got a packet in the mail saying that Division of Child Support did their findings and stuff. So I'm like, I'm kind of confused. I'm like, wait, are they both handling it, or is it just automatic that the prosecutor for Cowlitz County also starts it? So I'm not sure if I should disregard one or just, I don't know.
I'll let Ms. Powers speak to that.
Okay.
Thanks. Great question. This is Amy Powers for the state of Washington, Division of Child Support. We have gotten involved because the child is receiving state benefits, but our interest in your divorce is really limited to just making sure that if you enter a child support order, it has the correct medical language in it.
Okay.
It sounds like the Division of Child Support has decided to simultaneously enter an administrative order of child support. They sometimes do that when cases are in our office without giving us a heads up that they're doing that. So I did not realize that was in process. I would take that process seriously. And if you both are happy with the administrative order, you certainly can stick with it. But if you choose to enter a child support order in your case, then we're involved just for the medical language.
Oh, okay. Okay. Yeah. On, when I was going through their packet, it had to do with like, what he pays towards medical and stuff too, because she gets state medical. So that's why I called, a couple offices on both, and I'm like, I have no idea if I hope that they're not charging him twice because there's 2 different packets here.
No, if the court ends up entering a child support order, it will trump the administrative order and the administrative order will disappear. If the court does not enter a court order, then the administrative order will continue.
Okay. Thank you so much for clarifying that.
All right. That's it for today. We'll see you next week.
Okay. Thank you so much.
Very good. Is there anybody? One moment, get that one up. All right. I see you, Ms. Farr.
Good morning.
Good morning. All right. So it looks like when I looked in the file, I now have a consent from the mother that was filed earlier this month. Still don't have service on the father, at least from what I can see on Odyssey. Why don't you give me an update from your end?
Looks like it was the father has been served and the proofs of service were just filed yesterday. So we just need to set this out to give him the 20 days to respond.
Great. Okay, so what I'm going to do is I have an order here. Anybody wish to be heard on this matter?
Well, Your Honor, there is also one other issue, and that was that the CPS records haven't come back from DCYF yet. And so I'm not sure why, because that order was submitted quite a long time ago. So I'm just wondering if we need to submit a new order or...
Well, it looks like someone submitted a new order yesterday for the court for a motion and order directing DCYF. And so I signed that. So hopefully that will resolve that problem. And then I'm going to enter an order extending the current orders and set a hearing for August 17th at the same time at 10:30. That should give everybody a good amount of time to review.
That sounds just perfect, and I'll get my report in, and we should be ready to go on that date.
All right, very good. All right, that completes this matter.
Thank you.
Amy Powers for the state of Washington. This child is receiving TANF, so I would ask that we handle child support at the August 17th hearing. Now that the father's been served, we'll make sure copies of our pleadings go out to him. And we filed our proposed order and worksheets back in April.
Very good. Perfect. Handling it on August 17th will be Mr. Ignastu on that matter and Mr. Gojak on that matter. All right. Mr. Ignastu. Oh, you're muted, sir.
Sorry about that, Your Honor. I haven't had contact with the father, Daniel Howlett. I've tried to get it out. He was in jail and now he's not in jail, and no one seems to know where he's at. And
Here right now.
we have. Are you here?
Yeah.
Oh, okay. So you're Daniel Howlett.
Just graduated from inpatient treatment, and I just got.
You and I need to meet and talk.
Okay. Yeah. Nobody's gotten a hold of me or given me any letters or anything the whole time I was in jail or any of that.
Right. And the Miss Day has been appointed. She's been attempting to get a hold of him as well. What's the best way to get a hold of you?
I mean, the best way is to call my dad's number now until I get my phone in the mail. Because I mean, I've been in jail this whole time, and then I went to inpatient treatment, and then I just graduated inpatient treatment. I've only been home for 3 days.
Okay, Mr. Howlett, are you living with your father?
Right now, until there's an open bed at the community house. Yeah.
Okay. Would you provide the address where you're living so that Ms. Day and Mr. Anagnostou can have that? Okay.
I'm 17.
And Your Honor, just to clarify, I have had contact with Daniel. I was aware, I met with him in jail and at his home prior to his arrest. He has opted into drug court, and I knew that he was in treatment. I hadn't been able to reach him until now. So I will meet with him this week. I will make contact with him this week to follow up.
Yeah, I mean, I'm willing to do anything or whatever I got to do.
Okay, excellent. Make sure that you reach out to Mr. Anagnostou when you finish court today. You can call his office. Mr. Anagnostou, do you have a pen there, sir?
I don't have a pen or anything.
Okay, so you'll need to look up Mr. Anagnostou. He's got your number, but it's your job to reach out to him. So his name's Kurt Anagnostou. So it's your job to reach out to him when you're done with court. So you can schedule a time to meet with him. The court's appointed you counsel. These are complicated matters, and the court recognizes that. And as such as appointed you counsel, it's your obligation to sort of utilize that service that the court's appointed.
Yeah, if I would have been able to, but prior to this, I would have got a hold of him. I was just in jail, so I didn't know how to get a hold of him.
Yeah, well, we're all here now, so great timing that we'll be able to make sure that everyone meets up. All right, so with that, I'm going to turn to Mr. Gojak.
Your Honor, I've not had a chance to get in contact with the mother, Tracy Miller. My request would be to maybe set this over a week or two, just so I can try again. I was informed that maybe Facebook Messenger might be a way to get a hold of her. So I haven't tried that yet, but I will give it a shot, try to find her through Facebook. But yeah, so if the court would allow it, a 1 or 2 week set over would be great.
Okay. Ms. Day?
Yes, Your Honor. So as a court visitor, I've already completed my court visitor report. So under the statute, my duties are finished unless the court wishes to have me stay on as a guardian ad litem and continue to work with the parents and the attorneys and the petitioner and the children. And I'm happy to do that if that's what you would wish. If we are going to set this over, I would just ask that we set it out 30 days. That would give father time to kind of see what's going on at the community house, get in touch with them. He's having visits by agreement with the children. He is doing well. He is in drug court, so I don't have any concerns. The family is very protective and very supportive of him. So I think that's probably the wisest course of action. That gives everybody a chance to meet with their attorneys and kind of see where things are at.
All right, very good. And then Mr. Brad Deerheim, I see you on my screen as well. So the request largely seems to be to set over several weeks, give everybody a time to sort of get more information about either the party that hasn't appeared today or sort of other collateral cases sort of settling into what those are going to be. Do you have any objection to continuing the status quo for several more weeks while those things happen?
We're setting them over to get in contact with the mother, or what? What is the deal? What is that?
So the request is to set over for two things, really, to ideally get contact with the mother, between the mother and her attorney, and then to give the father and his attorney an opportunity to meet, and for his cases to sort of settle so that we know for sure if cases are getting opted into drug court, that that's actually happened. And so we know sort of what's going to be the expectation going forward.
Okay. I've told the mother multiple times about the court dates. So in my opinion, it's just lack of interest. So I just figure I would voice that. She's aware of where she's supposed to be today.
Yep, and I don't doubt that, but we do have the father here today for the first time, and him appearing, and having an opportunity to meet with Mr. Ignastu. So here's what I'm gonna do. Sounds like everybody sort of understands what's happening. Children are in a good placement. That's excellent. And I'm glad that that's supportive, and father's already had some visits. That's great. And I really appreciate everybody working to make those things happen. That is certainly in the children's best interest. So what I'm going to do is I'm going to take sort of an in-between position. I'm going to set this out to August 17th. That's about 3 weeks. Sort of that gives you an opportunity to meet with your counsel, Mr. Gojak, to hopefully communicate with the mother between now and then. Ms. Day, I'm not going to appoint you as guardian ad litem just yet, but I will ask you to appear on the 17th. The idea being that if there's a potential agreement, then potentially wouldn't need that additional report. If there's not, or we need additional information, that seems sort of the best moment to then launch that next piece of the investigation.
So that sounds great, Your Honor. I appreciate that, and I will submit for my fees as the court visitor. However, I am out of the country the majority of August. So if I am reappointed, certainly the attorneys could let me know. And I'll be happy to get started. I will be returning on September 5th, or back available September 5th.
Okay, very good. Thank you for letting us know that.
Your Honor, just to confirm, that was the 17th of August?
Yes.
Thank you.
All right. Any questions from any party on this matter?
No questions.
I just need to acknowledge you. That's my.
Right.
Yes.
Okay.
And I have your number too, and we'll try to reach out to you right now. Have my secretary give you a call.
Okay. I mean, just give me like 30 minutes so I can be back at the house. And then
That's fine.
Okay, awesome.
And for my purpose, the court is going to sign an order that extends the current orders placing the children with Mr. Deerheim. So that's going to continue. And the court's entering an order that extends it out until the 17th.
Okay, so it's still just an extension of the emergency custody?
Yes.
Okay. So I know there's like a time period that we have to be within. I was just wondering.
For this, because I have everyone present and everyone's essentially agreed, except the only party who's not present, the extension is reasonable. The court finds good cause.
All right, thank you.
All right. Yes. Anything further from anyone on this matter?
Nothing, Your Honor. Thank you.
All right. Do I have anyone present on that matter?
I'm present, Your Honor.
All right. Give me just a moment to get that case up. So it looks like in this case, the court appointed Ms. Day.
I think she left.
I think she did. Let's see.
And I've been playing phone tag with her.
Okay. So in this one, in this case, okay, so you did appear. There was a court hearing that you did not appear at previously. That's why we appointed Ms. Day to make sure that you appeared today. Okay. And then we extended guardianship. So what hasn't happened is it doesn't look like we have any service on mother or father. Is that right?
I filed proof of service on the day. I'm sorry.
Because I don't see a proof of service in my file. Oh, hold on. Might see it there. Okay, so we've got proof of service on Sandra. Oh, proof of service on Alicia. Okay. What about service on the father?
Service on the father was difficult because he's currently incarcerated in Arizona.
Okay.
Getting a hold of him was virtually impossible. I did call the corrections facility that he's in, and I was told that he was not allowed to be communicating with the outside world at the moment.
Okay. So here's what I'm going to do. In this case, so there are ways of serving people in custody or who are incarcerated or in prison. I can't give you advice on how to do that because in this sitting as in this role as a judicial officer, I can't advise parties on what to do or sort of how to process their case. But I would encourage you to reach out to legal aid or speak with an attorney about how to get him served, even if he's incarcerated. Does that make sense?
I was just more curious on the legality of the whole thing because the parents have already signed their rights away to the current legal guardian.
But you're starting a new case, and there's still, unless the child's been adopted, then
Okay.
at this point,
I
all those
wasn't
people need to get served, but because you're still then taking custody of the child. So parents are still parents unless their rights are legally terminated, and adoption takes place. So what I'm going to do is I'm going to enter an extension of the current immediate order. I'm going to set this over for 2 weeks. So it doesn't give you a whole lot of time. That's going to be August 10th. You need to be back before the court, and appear before the court. And then by then you need to have an explanation to the court about sort of that you've had him served or your plan for how you're getting him served. So reach out to legal aid today, tomorrow to make sure that you can get those balls rolling, because it's not always an immediate process, as you've probably learned. But that way we can get that service issue addressed, because the case can't really process forward until we have everybody served.
Okay.
All right. So we'll see you back here in 2 weeks on the 10th in this matter.
Okay.
There should have been one filed with the original petition, and I did sign the petition. If it was not, that's an oversight, and I'll remedy that for the hearing.
Okay. Just looking through. Okay. I don't see that with the original petition. So yes, if you would send in a notice of appearance, I would appreciate that.
Absolutely.
Okay. So in this case, looks like the child and parents still need, I don't have any proof of service in the file. Would you like to speak to proof of service?
Your Honor, I think right now, Ms. Jones, the mother, has been served. We are still trying to find the father. The address we had was not good, so we have an investigator trying to track him down. And so that's where service stands right now.
Okay. All right. And then Ms. Jones, I do see you there as well.
I can give you an address for the dad.
Okay. Why don't you go ahead and if you would just say it slowly, that'll make it easier.
Thank you very much.
Okay, great. I appreciate that, Ms. Jones. So where we are at the moment, did you receive a copy of the paperwork?
Yes, I did, ma'am.
Okay. And so the request is to establish a guardianship over Kayla. Are you in agreement with that, or are you in disagreement?
Not.
Would you like the court to appoint you counsel?
Yes, ma'am.
In appointing you counsel, the court needs a little bit of information about your finances. Do you receive any kind of state or federal aid, like food stamps or any kind of benefits?
I received SNAP. I'm located in Portland, so I received the Oregon SNAP, and I just started work yesterday.
Okay, I'm glad to hear that you started work. That's excellent. Because you're receiving a income-based form of aid, the court can appoint you counsel. Would you like the court to appoint you counsel?
Yes, ma'am.
Okay. Give me just one moment. I'm going to check with my clerk. So, Ms. Jones, what I'm going to do is I'm going to reach out to court administration to work to find you an attorney. What is a phone number that we can reach you at? So what I'm going to do is I'm going to talk to my court administrators who kind of keep the wheels turning in the background here. And they're going to work to find you an attorney that can be appointed to you. Because you want to be able to speak to them and file things into the court record. This is the way court works here is that everything has to be filed for me to be able to consider it. So it's not a trial like you would see on TV. Everything has to be filed via declarations, kind of like what you received when you got that paperwork for me to be able to consider it. And I want to make sure you have.
I spent the last 3 days trying to find a lawyer to help me get stuff for you today. So
yeah, and that's very hard, especially when you're out of state. I recognize that. So the court is going to work to find you an attorney and have that person call you. So just make sure if you receive a call from an attorney located up in Washington that you respond right away to give the two of you the most amount of time possible to be able to respond to the court file.
Okay.
All right. Looks like the father still hasn't been served yet, but thank you for providing that information that may help bring him into this hearing. I always appreciate that. So where that leaves us is child still needs a placement pending us being able to receive information from you and potentially father as well. So the court's going to extend the current order. I'm going to extend it to 2 weeks. 1 week would be a little too short for you to be able to actually meet for court administration to find you an attorney, for meet with them and then get things filed. So I'm going to set that out 2 weeks, and that's going to be to August 10th.
Day after her birthday, her 16th birthday.
And then hold on. And then just save your question for 1 minute and then I'll get back to you. And then as the child, because
what time is that at on the 10th?
This can be the same time at 10:30. So exactly how you logged on today, log on that day.
Okay.
As far as service, has the child joined or consented in this action?
Your Honor, she has. We do. I think we need to file proof of that. But this,
Okay.
yeah, this is at her.
Okay, very good. I just don't have that in my file. So if you can get your notice of appearance filed as well as any proofs of service, you very well, Ms. Jones is present today, acknowledges service. But that being said, if you would file that proof of service, and you may have done so, it's just not made it. It takes a couple days for after they arrive at the clerk's office to get scanned in and make it to my system. All right. So what we're going to do is we're going to put this matter out 2 weeks to the 10th. Everybody should appear at that time. Anything further or any questions from any party on this matter?
Yes, I would like to be able to have a visit with my daughter. Her birthday is August 9th and it is her 16th birthday. And this whole thing is set up because I've asked for visitation with my daughter.
Okay. I'm not going to make any rulings on visitation today because I don't have anything in the file to base that on. That's not to say that the court won't do that on the 10th. So I appreciate that these are very challenging matters though, and very difficult.
After her birthday.
So that's my order for today. We'll see everybody back here on the 10th. I have Mr.
Thank you, Your
Honor.
Yes, Your Honor, I represent the petitioner, Marion Barrett.
Okay. Thank you. I went through the materials. My most significant concern when I went through the materials is jurisdiction. So clearly there's other states that have, where these children have, or at least the parents have resided. When I looked at the petition itself that had been filed, sort of that section was a little lighter than intended in the sense that the in which state is kind of left blank in some of those sections. So can you tell me where the children have been residing?
Well, they've been residing with my client here. They resided here in Castle Rock for a long time, and then I'm not sure she's present and can tell you the history. They left for the parents left and took the child to Chicago, and I'm not sure how long ago that was, but. The child did reside here and actually went to school here in Washington State, has connections here, and has been back here for, I don't know, a month or so, is my understanding, but I could clear that up. I mean.
So Ms. Barrett, can you unmute and just without getting into how or why, where have the children been living for the last, let's say, 1 year?
Sure. One child. Just for the last year, in and out of my house until October, late September, early October of 22. Michael came and picked up Flynn and Georgia. They went back to Chicago. Georgia called me about 2 weeks later, said that he was abusing her and asked me to come and get her and Flynn. I did. They came back here. And then at the end of March.
So hold on. When did they come back? So you said you went out to get them? Okay. So they went in like within the same month or 30 days, essentially. They went to Chicago and came back.
Yes.
Okay.
And then they went back to Chicago at the end of March of this year. And about 3 weeks later, Michael beat up Georgia, went to jail. Georgia gave Flynn to Michael's cousin with a document that said she could have Flynn for 1 or 2 years while she gets her life together. She told me that she wanted to get back together with Michael and live as a happy family. I called CPS.
When did the children, this is a very narrow question of just where and when, not sort of the underlying facts. I know for many. When did the children come back to Washington?
June 26th.
Okay. And I'm just going to I'm going to have you raise your right hand.
Oh.
Do you swear, promise, or affirm that the testimony that you just provided me is the truth under penalty of perjury?
Yes.
All right. Very good. The truth. All right. So given that information on the record, the the court finds that Washington is the correct state and Washington has jurisdiction. It doesn't look like the children were ever in Illinois for more than 6 months. And if the children previously lived in Washington, then they are Washington residents. Court has jurisdiction. Okay. So that being solved and settled, that lets us move forward. So looks like in this matter, I didn't see service yet on the parties or on mother and father. Mr. Ignacio, you want to speak to that?
Sure, Your Honor. We have a process server in Chicago trying to obtain service. And we haven't been able to get service yet. So I was going to ask that we, given the circumstances and the facts as set forth in my client's declaration, to have an ex parte emergency order continued for maybe 2 weeks. I should be able to effect service and we can be back to see what we're going to do going forward.
Okay, very good. That seems reasonable. Mr. Ignacio, are you planning to submit an order to extend to the court?
I can, sure. I can get that to you.
Okay, so I'll ask that you go ahead and propose an order. I'm going to set this out 2 weeks as requested to August 10th. And that'll be at the same time at 10:30. Children will remain in custody of your client pending that seems appropriate. And my clerk's going to just make the note in the court record or in the minutes that the court found jurisdiction. All right. Anything further on this matter, Mr. Ignacio?
Nothing further.
All right. Very good. Court will sign that order when presented.
Okay, I'll get that to you.
All right. Thank you very much.
Thank you.